9, 8, 7, 6, 5, 4, 3, 2, 1.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hello, everyone. I'm constitutional attorney Catherine Henry, or Constitutional Catherine, and this is Liberty Lori joining me for yet another of our wonderful Restore Freedom Weekly episodes. This just happens to be Season 2, Episode 15 of Restore Freedom Weekly, and today's topic is Ipse Dixit in the legal context. So for some of you, you might, hey, if you've been following my legal work and my fight for freedom for years, you've heard me talk about that term. But the rest of you are probably like, what the heck's wrong with her? And why is she using made-up words? Yes, I know attorneys often sound like they're using made-up words, but this is a real, legit term. So with that being said, let me see here. That is strange. Okay, so yeah, it was showing me there were comments, but it wasn't showing me what they were. So now I see one of them. Happy Tuesday from the Liberty Cause. Hello, and thank you for joining us today. So today, what I want to do is I'm going to grab my trusty Black's Law Dictionary, and I'm going to open it right on up to our term that we're talking about today, Ipse Dixit. So, as we mentioned, what the heck is it? That's the first one. And hello to Jeff joining us on YouTube from Michigan. We appreciate you joining us today. All right, so Ipse Dixit is a Latin term that means something asserted but not proved. Something asserted but not proved. He himself said it. So basically what it is answering the next question, how is it used by attorneys? What does that mean for the legal context? Well, as Lori so pointedly found a photo to use for our thumbnail today, Ipse Dixit is Latin for because I said so. Have you ever had that situation happen by government officials, prosecuting attorneys, you name it? I have certainly seen it time and time again. It is because I say it is. Really? Well, that might work for you as a parent to your own children, but certainly not when you're a government official or an attorney in a court case. But yet it happens all the time. So what are some examples? Well, I'm just going to give you some that I've seen in my own cases. So for example, in my Allegan County case, most of you by now at least know about my Allegan County case. They were basically saying that the case was simply about prohibited parking and had nothing to do with constitutionally protected free speech or a number of other statutes and constitutional provisions that protected my right to be on the public property during the time it was open to the general public. But simply them saying the case had nothing to do with my First Amendment rights and that the Constitution didn't apply didn't make it so. They didn't prove that in any way, shape, or form. In fact, the U.S. Supreme Court has said that a township, or quite frankly any form of government, may not, by its own Ipse Dixit, destroy the public forum status of such property, such as a township hall and things like that. Nor can they exclude people from such a public forum in which all parties have a constitutional right of access. Yes, you heard me correctly. For all of you who've been struggling with being kicked out of publicly accessible places in the last 3 years because of, your medical status or, wanting to breathe fresh air, a number of things like that. They can't do that. And the U.S. Supreme Court said that many, many, many years ago. Okay, so from my own brief, I used it against them. So let's see here. All right. So I said in one of my briefs to the Court of Appeals in Michigan in 2021 that the prosecutor and the court surmised this case was merely the trespass of a car. No joke. It's not a thing, but that's what they said. Separate from my protected petition circulating. And this is what I wrote word for word. But the Ipse Dixit, it is because I say it is, and no proof is needed model doesn't work in the law, especially as a prosecutor shall not prosecute any person for conduct presumptively protected by the First Amendment. Now, where did I get the last little bit of language? It's not just from the First Amendment. No, I was actually quoting a Michigan statute, 750.543 Z as in zebra. In case you live in Michigan, check out that statute because it definitely applies in a lot of situations, not just my own case. All right, so I actually use that term in a lot to demonstrate how the trial court itself and the prosecutor did a lot of that Ipse Dixit stuff. Oh, it just is because I say it is. No, you don't make the laws, even if it's the judge we're talking about. They don't make the laws. Case precedent is not the same as actual statutes and law. And certainly case precedent is not made by trial court judges anyway. So anyway, a quick, oh my goodness. Mr. Mr. Catherine Henry, the super sexy guy I'm married to says that live chat works in Rumble now and he will see us there. Well, thanks a lot, babe. But as you know, live chat, I think, has worked. It's always worked for us. The problem is it doesn't work with the streaming software that Rumble requires you to use in order to go live. So Lori does her best to try to go back and forth and keep up on the live chat. But it just doesn't work the same for us as seeing the other stuff. Speaking of which,
they did change it for in the Android app. I think I heard some people talking about they changed where you can see the chat. So for me, it was right in front of my face, but I guess it wasn't on the Android. So
yes, Android. Okay, so I see what you're saying, Mike. Is that it works on the phone, whereas it didn't work before, but on the computer, it has always worked for us. People have been able to comment if they had certain devices where they were watching it, etc. But I see what you're saying. Okay, so, and you're right, the Liberty Cause. Government doesn't own public property. The people do. In fact, they own it. The government does own it, but they own it in trust for the people. The purpose for which they own the property has to be for the benefit of the people. And there's a whole bunch more if you need any information on that, some case precedent, even from the U.S. Supreme Court.
Easy logic would be the government was created by us. It wouldn't exist if not for us. And so, of course, anything we do, I don't know. That just something that came to my head.
Yes.
Keeping the people's mind that we're above them. It's not that we, like me individually, I'm not above them, but we are above them.
Right. Exactly. So here's another example, and you guys might find this amusing. So any of you who have been paying attention to what's happening currently to us, the Henry family, here in the city of Ormond Beach, Florida, we have a lawsuit pending, which actually stemmed from the city's illegal and unconstitutional enforcement upon us for alleged land development code violations. Okay, so 3 different things: our privacy fence, our pavers that extend our driveways, and we have 2 shipping containers because we have a house built in 1949 on Beachside that doesn't have a garage, and code requires a garage. So anyway, so the city started that case and has proceeded very illegally and unconstitutionally, violating all kinds of procedural protections along the way. And I filed a notice of appeal to go up to the circuit court. And in that notice of appeal, I included a notice of joinder. So what does that mean? I was joining in claims and parties. So I was joining in my compulsory, my mandatory counterclaims against them because it's all about the same issue, the same transaction or occurrence. And I was joining in new parties because technically the deputy city attorney, the neighborhood improvement division officer, and her supervisor weren't themselves parties to the underlying case that they brought against me, but they should be. So I put a notice of joinder of parties that they were being brought into my lawsuit in their individual capacities. Yes, having the pantsuit off them individually.
I
And
wonder
so,
if it might be good to pull up your, so people can read where you said that,
um,
or is that kind of more complicated than?
if you want to
Because
throw
you're
that in,
talking about doing that, or I can throw the link to it in the chat. I
that
was
would be
just thinking
awesome.
if they could visually see where you said that.
Yes.
So
yeah, so Lori, I'm sure will throw you guys the link that's on our website. If you go to restorefreedomkh.com/resources, or just restorefreedomkh.com, go to the resources tab, you'll see case documents. I believe it's the very first link, and then go to the Ormond Beach case, which I believe would be the very first link on that list. You'll see all the documents that have been filed so far in this case. And you'll see the stuff originally filed at the, if you want to call it, trial court level with the special magistrate, but you'll also see the new stuff that's been filed at the circuit court. Now get this, the city attorney themselves, they have never filed anything in this case at all. They never filed responses or written, anything. It was the neighborhood improvement division inspector that filed the request with the court. They had all the materials and basically presented the case in court to the special magistrate in February. And then when I filed my motion for stay and relief from judgment, special magistrate didn't respond. City attorney didn't respond, didn't file anything. When I filed my notice of proposed litigation under Florida Statute 70.45 in November that they legally have to respond to within 90 days, they did no such thing. They have filed no response. And it took me filing my emergency motion for stay and for relief from judgment at the circuit court and the circuit court judge to order them to file a response by April 20th for the city to actually file through an attorney an actual response. Now get this, it's 4 pages long. Yes, 4 pages. And that includes their supposed response to my motion, their motion to strike my notice of joinder, meaning I'm not allowed to join in my own claims or include the people that I wanted to sue personally in this. And I'm also, they want me to, so it's their motion to strike, but they also want me to post a $13,700 bond just to keep my property while the lawsuit is going, just to keep my own homestead as it is, right? To post a $13,700 bond on top of the thousands of dollars we've already paid. Anyway, there. See,
does the word reasonable fall? Sorry, Neffy.
Even a dog can understand that that is ridiculous.
The word reasonable seems to fall off here. I think in law, we must always be reasonable. So depending on the crime, the reasonable repercussions. So that they think that by saying you should bond that much, to me, it sounds like you are destroying your neighborhood and your every single neighbor's life's in danger because you haven't taken care of this. That's the impression I'm getting.
Yeah. So they're saying that this is also something that I should be, it's not the total amount of damages that they would supposedly seek from me, but it's the start of the amount of money they think that I need to pay. So isn't that cute? Now, here's the thing. What they said in there, I want you guys to check it out. I've been working on my response or my reply to their response, And so they just sent it. They apparently filed it late on Thursday, the deadline, right? I filed my emergency motion April 3rd, and it was virtually the same motion as it was that I filed on March 24th. So they've had basically a month to file a response, but they waited the whole time and then filed this sad little piddly 4-page document. And I didn't get it served to me through the e-portal until Friday, and didn't get a chance to really look at it too much over the weekend. And so I spent the entire day working on it yesterday and so far yet this morning. So I didn't have a chance to pull up, and take screenshots and do all kinds of pretty things that I like to try to do in the slideshow for you guys. But check out that part of the website. I think you can actually go to restorefreedomkh.com/OB case, I believe, is the link to all the documents, and use them as you see fit. There's documents on our website for Michigan cases, for Florida cases. There's a lot of U.S. Supreme Court and U.S. Constitution stuff that's cited. So no matter where you live, there's stuff that you can use in your own situation. And not just in a court case, you could use it in putting together documents or letters or requests or whatever with any kind of government official before something actually gets to the point of a lawsuit. So please, by all means, check all those things out. But today's point is about Ipse Dixit. And so in their request, in their piddly little 4-page response, they say a lot of things don't apply. They literally come out and say, oh, well, she, here it is. As the basis for the attempted joinder of counterclaims and non-party city employees, appellants, which is us, the Henrys, appellants rely on rules 1.110, 1.140, and 1.170 of the rules, the Florida Rules of Civil Procedure. Those rules, however, are inapplicable to the appellant's appeal. Okay, so you might think, oh no, right? If you're in my shoes, I'm not a Florida licensed attorney. I'm just the average Joe, just like most of you that are watching. So I'm like, well, shoot, I didn't go to law school down here. I didn't take the Florida bar here. Oh my gosh, maybe they're right. And so I went and looked and double checked and, oh my goodness, maybe the rules are. So Michigan and Florida, it is what it is as far as the rules. They're basically the same. They're broken up into different chapters of court rules. We went over this specifically in some recent episodes, but basically in Florida, it starts with the rules of civil procedure. That's chapter 1. Chapter 2 is what they call the rules of general practice, which is civil procedure, criminal procedure, basically any kind of court case. And then they have other kinds of cases, probate cases, juvenile cases have their own set of court rules. Criminal procedure is another chapter. Appellate procedures, chapter 9 in the Florida court rules. Now in Michigan, she can't be a party if she can't be an attorney for the city if she's also a named party. So they brought in outside counsel, and I'm sure my tax dollars are paying him a whole heck of a lot of money to do very, very little. I mean, what could he possibly say in 4 pages, right? So his motion to strike is basically just to say the rules don't apply. The rules of civil procedure don't apply in appellate cases. Let's think about that for a minute. The rules of civil procedure don't apply in criminal cases, or in appeals cases. Well, in Michigan, there's a court rule that says the rules of civil procedure apply in all cases unless there's another rule that specifically says it doesn't apply. Okay. You can find out all the details about that in my procedural due process appeals that I filed in the Allegan County case. But down here, I'm like, man, maybe they're right? If they're saying it's true, it must be true. I mean, maybe their document here is so simple, and it cites, cites maybe 6 or so court rules. There's no cases, there's no statutes. It's just, court rules. Maybe there's something to that. Simple and sweet. Okay. Yeah, let's look at that. So I looked at the court rules, and there's 2 in particular that I found very special. Let's see here. Well, where'd it go? I lost it. 1.010, okay? That's in Florida. And that rule says that these rules apply basically in all actions, okay? And so if you read, there's some exceptions that it talks about, but it doesn't exclude cases that the appellate rules apply to. In fact, in the let's see, the rules of general practice, that's chapter 2 in Florida. It'd be chapter 1 in Michigan, but anyway, it's chapter 2 in Florida. Rule 2.130 specifically calls out the Florida rules of appellate procedure and says that those rules have priority in appeals cases, not exclusivity in circuit court appeal proceedings. So kind of interesting that my point is oftentimes attorneys, especially government attorneys, will claim something is true. They'll say, oh, this law doesn't apply. That's what I've had a lot of them say to me in different cases throughout the years. This law just does not apply. Your rights do not apply. The Constitution does not apply. And then they don't have anything to back it up with. I mean, nothing, not even case precedent, right? Not even their case law that they rely on. Nothing. Just it doesn't apply. That is the epitome of Ipse Dixit. It is because I say it is. Is that really how we run things? We get to cherry pick and say, well, that I'm going to pick to not follow that law or that constitutional provision or that court rule because I just don't want to. And I'm going to tell you, it just doesn't apply. And we're just supposed to go, oh, okay, I guess it doesn't apply. No, make them prove it. Make them prove it. So before I get too far off, what can you do about it when especially a government attorney does that? Could be an opposing attorney in a civil case too. But what do you do about these situations? You literally go back to the basics. I want you to trust your gut. I want you to trust your knowledge. I want you to be able to know how to represent yourself and not rely on attorneys or government officials or legislators or lobbyists or anybody else to advocate for you because you would do the best job advocating for you. I've been trying to educate people for years on how to educate yourself to represent yourself. The reason why I'm saying you got to put in the work, though, the only reason why that would work at all for you to represent yourself or to be able to fight for yourself in any capacity before something gets to court, trying to prevent a court case if it doesn't have to go to court, etc. The only way that works is if you actually put in the effort and you do your research. Now, don't listen to all the conspiracy theory bullshit that's out there. Don't just take some attorney's word for it. I don't ever tell you to take my word for it. I'm telling you where to look. I'm telling you what things apply in situations, and then I tell you where to look. And I expect you to do that homework. I expect you to follow through, check out our Wednesday Way to Get Involved challenges, utilize those freedom fighting tools on Friday. Listen to the Cliff Notes version of our episodes that we have in the Constitution segment recap videos on Thursdays. Do all that so that it's being ingrained in you, and each of those messages are actually sinking in and you are learning it, and you're not just cramming for some test that might happen someday, okay? Now, why is that so important? Because if you truly read the documents for yourself, before you ever touch cases and worry about case precedent and all kinds of other garbage, go to the court rules themselves. Go to your state's statutes themselves. We've had a lot of get involved challenges and different things tied to literally getting you to go to your state's list of statutes, the table of contents essentially for all of your statutes, and reading the whole table of contents, expanding them. Usually they can expand a little bit and you can see the subdivisions in each chapter or the chapters within each title, but checking those out yourself. Again, you're not going to get to the point most likely of reading every single statute on the books, but you can at least familiarize yourself with the topics that are there so you can more readily know where to go when something comes up. Now, I think I had it in a recent Get Involved challenge for you to check out the court rules, to read the table of contents to know what, how your court rules are broken down and what kinds of things they talk about. Look at those table of contents or the list of categories or whatever it's called in your state. Look at it regularly. I mean, just take 5-10 minutes here, or maybe, spend an hour a month on it or something. Do something so that it's sinking in and you're kind of looking at it from a different lens, a different perspective, so that when something comes up, when you have a government official or a city attorney or an overpriced private attorney representing your city who's challenging you and trying to shut your freedom down and trying to shut down your procedural due process that's guaranteed to you by the U.S. and state constitutions, that you're able to stand up and say, no, that's not how this works, and I'm not going to tolerate it. But have more than just Ipse Dixit to rely on yourself. Let them be the fools and the ignorant people that just show up to say, it just is because I say it is. Let them be the imbeciles who put together a 4-page response, and that's all they've been managed to muster in the last 6 months on a case. Shoot, I put these people on notice that I was suing the crap out of them on November 8th, 2022. Told them why what they were doing was illegal. I told them the crimes they were committing. I told them the civil case, penalties that they would have coming their way. I put them on notice on November 8th, 2022, that this was coming for them, and they couldn't figure it out. I've never had one written response to any of the legal issues I've raised until Friday. And that is a 4-page bunch of gobbledygook nonsense of Ipse Dixit. It is because I say it is. They cite rules that don't apply, and I don't want them to, so they don't. That's all that they did. Now, oftentimes, the sad thing is, you might have a court, you might end up with a judge that buys into that. Maybe they're part of the same good old boy network, and I don't know. Maybe that is for the judge and the attorney that I have here. Maybe that's the situation. What I'm hoping, though, is regardless of what kind of tactics that this attorney has used in cases and situations so far, and regardless of how the judge may have ruled on prior situations with this attorney, I'm hoping that this judge is going to at least read what I'm saying and pointing out certain things. Now, here's the thing you need to do. You need to read those court rules at least at the very beginning. There's always something called scope or purpose, general intent, something like that. Look for that at the beginning. Now, in the state of Florida, the court rule I'm talking about, there's actually a little bit at the beginning of each chapter, right? Because it's telling you the scope of each chapter of the rules. So I have the whole rule book in front of me, yet I'm struggling to grab what I want. Okay, so the Florida Rules of General Practice, it's 2.110, scope and purpose. All right, and scope and purpose. These rules apply to the administrative matters in all courts to which the rules are applicable by their terms. The rules shall be construed to secure a speedy and inexpensive determination of every proceeding to which they are applicable, and these rules shall supersede all conflicting rules and statutes. So even if there was a law on the books that said these rules don't apply, sorry, they do. But then in Florida, the Rules of Civil Procedure 1.010, scope and title of rules. Michigan, same kind of things. You'll see in my briefs that I have online. You could check out the procedural due process appeals briefs from Allegheny County. Procedural due process appeals briefs. Check those out. You'll see where I talk about, I cite the exact court rules in Michigan showing how the civil court rules apply in criminal cases unless they specifically don't. But the scope of the Rules of Civil Procedure, where did I go? These rules shall apply in all actions of a civil nature and all special statutory proceedings in the circuit courts and county courts, except those to which the Florida probate rules, Florida family rules of procedure, or small claims rules apply. It doesn't say except for appeals. Okay. So one thing you want to look for, though, as well, is this is something I want you to consider. Let me pause for a second. Court rules are not law. John James on YouTube says court rules are not law. You're right. You're right about that. But take a step back, a giant step back, and just think of it in this sense. It makes sense in any given situation, whether we're talking a city council meeting, a trial court, at a circuit court in Florida or Michigan or whatever, for a state legislature, whatever it is. It makes sense that that particular government body has a rules of procedure established so that people have expectations, clear expectations of how to participate. Because although you might view it from your perspective as, oh, those kinds of rules are just meant to keep me out and trip me up on procedural mishaps or whatever, and that does happen, and that's why I do my best to educate you on how and where to look for things. But they also serve to keep other people from abusing the system or doing things in a way that you wouldn't have notice of. The purpose of having rules of procedure is so that everyone can be put on the same page, so that we're all supposed to know what the same procedure is in order to file a certain case or pursue a certain claim in the law. I'm not saying I agree with all the court rules out there. In fact, if you look at the Restore Freedom Initiative constitutional amendment petition that I drafted in May of 2020 to amend the Michigan State Constitution, you will see where we talk about, I have a section dedicated to what is the law. Is it court rules? Is it executive orders? Is it any number of administrative rules and regulations? I very clearly articulated what was and what was not the law. And so I was trying to clear up any confusion about that. But we didn't get the signatures. That didn't make it on the ballot. And so it is what it is right now. But anyway, stares at plants. One comes from the legislature. So he's saying that laws come from the legislature, and the other comes from the judiciary. The court rules come from the judiciary. Now, there is a court rule in Michigan as well that says that if a statute, if a state law about court procedure contradicts a court rule, the court rule supersedes that. Why? Because you start to also have oh my gosh, I've lost the concept. The three different branch separation of powers, separation of powers issue, where you don't want the legislature to control how the judiciary does its job. It could say, what laws are and what causes of action there are, what kinds of things you could sue for, that kind of thing. But in terms of how you file a case, generally speaking, that's more of a judicial thing. Just like you wouldn't want the judicial branch determining how to set up, or the executive branch determining how to set up the legislative processes, which I think all the processes should just be laid out in the state constitutions right from the get-go. So there's no argument, there's no confusion, there's no gobbledygook, but it isn't how it is. So anyway, just telling you what the purpose of those would be. Okay, so, well, Lori, I'm going to just expect that you're continuing to do the job you normally do and check out the comments and throwing them up there if I'm supposed to see them. And unfortunately, I know I was on a roll a couple times and I saw there was a comment and then I didn't see it. By the time I looked down, it was gone. So hopefully it was good with other people seeing it and not just me addressing it. But
well, since you're on a pause, John James did say some good things while you're kind of like teach yourself. Actually read the law first and then understand what it says second. And I thought those were important. And it's not going to happen overnight. A lot of my learning is learning when she's teaching you guys. So it's you don't expect them to just get it right away, and you actually are encouraging them. Look, this isn't gonna all sink in. You're gonna be overwhelmed, maybe, and stuff. But once you start really understanding it, and you really get a true understanding of the Constitution, everything else kind of it makes it easier to make that make sense.
Yes.
So taking that time.
And real quick, I see Joe on Facebook has had several comments. This one, courts will rule something constitutional even if it isn't. And that's exactly what happens in a lot of cases. And that's why in 2020, just clearest example, I was the only attorney that stood up front and center on the steps of the Capitol, in front of news crews, Fox 2 Detroit, Fox 17, Grand Rapids, whatever, stood up in front of anybody and everybody across the whole state. I sent out letters to every single prosecuting attorney and every single law enforcement agency across the state of Michigan. Hundreds of them. I mean, I sent out thousands of emails. Why? I sent them a letter on Mother's Day weekend. I used up my Mother's Day weekend to put this together to explain to them how following executive orders and enforcing them as law against the people was unconstitutional, regardless of what the governor said, regardless of what a court would say. It was unconstitutional, and that those individuals, if they wanted to use an executive order to enforce against a person that, and say that they've committed a crime, that they would be personally responsible for that. So it is absolutely true that courts will oftentimes say, oh, it's constitutional. I mean, let's look at the Second Amendment stuff that's come out recently. The New York and Bruin case, New York rifle case, and the following cases that have come out about that. Basically, a lot of people were like, yay, oh, look, the court's all like pro Second Amendment. And I'm like, then why didn't they start off the opinion saying, we have a Second Amendment. It protects the right to bear arms. Any laws that infringe upon that right are unconstitutional, period. The end. That's where all this stuff about history and all this other BS, no, that's not, no. What about the Dobbs case, right? Yay, it overturns Roe v. Wade. Okay. I was probably one of the only people that was like, all right, it's a start. It's not what we need to be excited about. Why? Because they didn't have the guts to come out and say what they needed to say what was actually in the Constitution, how the Constitution protects our life, liberty, and property. Our life, liberty, and property. That the word abortion or murder is protected nowhere in the Constitution, but life is in every U.S. and state constitution. So it's absurd to me why we could complicate things and stretch things so that, the government gets away with what it wants to, and, we can do all kinds of stuff. So, looks like Lori switched what was on there. I didn't realize that. Approaching Target on YouTube says, like you stated before, every member raises their hand for the oath if they kept it. No worry what branch of government it is. Yes. Every single person in government at every single level of government has to swear an oath to uphold the U.S. Constitution. And if you're in a state or local office, you are swearing to uphold your state constitution as well. Why is that so important? Because the supreme law of the land is the United States Constitution, and we have to follow it. The government doesn't get to just make up its own authority and do whatever it wants to just because it says it can. Ipse Dixit is not the supreme law of the land. The Constitution is. Joe on Facebook says, reading law often pisses me off due to the unconstitutionality. Yes. In fact, back when I was in high school, maybe college, at the early years of college. Granted, I started college at 16. But way back at the early years, I realized even at such a young age that our laws were so contradictory and so complex. And just for those two reasons alone were unconstitutional, because you're obviously denied due process of law if there's so many laws in the books that no one judge or attorney could ever even be master of them all, let alone the average person. And when they're contradictory, well, clearly that's a huge problem as well. So you need to educate yourself. You need to read the law. You need to educate yourself on the law, the court rules. The court rules is what I'm talking about now, because that's where, well, for me, off the top of my head, it's what's at the top of what I'm working on right now, because that's the pleading I was served with. It's basically all about the court rules, and the court rules don't apply. And so I'm trying to show you where they do. Sometimes you get lucky and have an attorney who's that much of an idiot that they just come out and say, these court rules don't apply. And then you can easily go to the court rule that says they do apply, and you can go from there. Sometimes they kind of beat around the bush, or they allude to that, or they just don't follow them. And you have to say, hey, now, for example, here's something I want you to consider. Now, this is a rule in Florida and Michigan, and is most likely a rule in whatever other state you might be in if you're in a different state. When you have a motion, when you file a motion or a response to a motion, when you ask the court to do something, you're supposed to use consecutively numbered paragraphs. Paragraph 1, paragraph 2, paragraph 3. Number your motions in that way. Why? Because then it's easy enough to refer to a paragraph that it could be stricken, or it could be focused on, or whatever. The other side could reference a paragraph. But here's the thing. It makes the court's job a lot easier to determine what somebody is agreeing to and where the differences are, where the points of argument are. So here's another court rule that is in Florida and in Michigan, and is most likely in your state as well if you're in another state. If you have a motion or any kind of pleading where you're asking, one side is asking the court for something, and then the other side then is usually required to respond. Not always. You could be a criminal defendant in a misdemeanor case, for example, and 9.9 times out of 10, you could sit back and say absolutely nothing, and you are not required to file a response. You might want to, but you're not required to do that because the prosecutor has the burden of proof. However, in all types of civil cases and in certain other situations, you are required to file a response if the other party has filed asking the court to do something. Okay. So if you're required to file a response, the court rules say that you then have to address all the things in that person's motion. So for example, let's make this easy. Me, Catherine Henry, I filed a motion, an emergency motion with the court saying, hey, the special magistrate's orders, they're void. There has to be a stay put in place. You can't enforce the orders. They can't come take my stuff, blah, blah, blah. Okay. That was my emergency motion. The court ordered the city of Ormond Beach to respond by the 20th. Now, the court rules I want you to pay attention to say that when you file a response, you have to respond to all of usually the term is called averments. I didn't write these terms, guys, but basically any allegations. They want you to number your paragraphs like we talked about, and all the stuff that's about one idea is in a numbered paragraph. And then the next fact or the next law or whatever is supposed to be in another paragraph, another numbered paragraph. And then in your response, you're supposed to respond to each of those numbered paragraphs. That way, the parties, everybody can know, the court, the plaintiff, whatever, everybody knows where the disagreement is. Oh, okay, they agree that that's the law. They agree about those facts, but they disagree about these facts over here, or that this law applies here. Okay, that's the purpose of it. This special attorney didn't use any numbered paragraphs, nor did they respond to my numbered paragraphs. and literally didn't deny virtually anything in my document. Didn't deny that the special magistrate failed to have subject matter jurisdiction. Didn't deny that when you want to physically take somebody's property, you have to file it as an eminent domain case. Didn't deny that I had zero notice that they were actually trying to physically come on my property, take my pavers, my privacy fence, and my shipping containers until 2 minutes before the hearing started, when they buried it in a request of a whole stack of paperwork. Didn't deny that they were cherry picking the law. Didn't deny that they were cherry picking enforcement of the law. Didn't deny that they skipped every single procedural step along the way in order to do what it is that they claim they can do. They literally didn't deny any of that. So why am I telling you that? Because I'm not a Florida licensed attorney. So I would be just like you, any other person. I went to the court rules yesterday and I said, there's gotta be a court rule down here like the one in Michigan that says that they have to respond, and for at least for the purposes of this motion, if they don't respond to that allegation or that averment, that paragraph, then it's treated as though, if they don't deny it, it's treated as though it's accepted. I don't know the word I'm looking for here, but they're admitting it. I found that court rule here.
Isn't it like a matter of fact because they didn't dispute it? Or does it not take it quite that far, but nearly?
Well, it's some of them are facts and some of them are laws. So when I say, there was no subject matter jurisdiction, that's a legal conclusion, but they didn't argue it. So it's taken as it is. They can't later on say, oh, well, of course the court can do whatever. No. So that's why I want you guys to know at least the basics. I don't have all of these court rules memorized. There are, especially when these dummies violate so many of them, I couldn't possibly keep that many of them memorized. No, but I read them, I research, I look at that table of contents. I've downloaded the documents, so I have them in PDF, and then I can do Control F and search for certain terms, joinder if I was looking for that, or service if I was looking for how a document would be served, or whatever the term is, right? I look at the table of contents and I literally read the whole thing and see, would this apply? That might apply. I'm going to read that again. And then I'm going to, and I've already read them all the way through 3-4 times at this point, but I don't have them memorized. So I was thinking, gosh, in the interest of justice and fairness, there must be some rule in Florida that's like Michigan's rule that, at least for the purposes of this motion, if they don't respond to an allegation I make, then it's deemed as true. They can't challenge it later. And there is one. So if you're looking for any of the exact citations for that, I'm going to be finishing up my reply to that and filing it with the court today. I will then put it on our website on that Ormond Beach case page, which I believe, I don't know, Lori, did I say it right? Is it restorefreedomkh.com/OB case? I think.
I don't know. I'll have to look.
Okay.
I can't remember either.
I'm pretty sure that's what the short link is to it. Otherwise, just go to restorefreedomkh.com, click resources, case document, so too, Ormond Beach. You'll get there. So I'll add it there. You'll be able to see it. Or just go to restorefreedomkh.com/OB case, because that was just confirmed as the correct link. Excuse me. And then you'll be able to see all the references that I make there. It's not going to be some super long brief. Don't worry about that. But it is something for you to check out. And again, even if you live in another state, just to see some of the concepts that I'm talking about, how, you shouldn't just assume that the civil court rules, the rules of civil procedure don't apply in an appeal or in a criminal case or whatever the situation is. So some of those basic concepts. So the best thing that you can do to combat the idiocracy of the Ipse Dixit way of doing things, where it is just because I say it is, those rules don't apply just because I say they don't apply, is to know the rules, to study them, to know how to go back and refer to them. And let me put it this way. When their response to my motion said, the appellant relies on rules 1.110, 1.140, and 1.170, but those rules don't apply to her appeal. I had to go read them all again. I had to go back, put sticky notes. Okay, so these are the ones he said that don't apply. Okay, well, actually they do apply. I didn't assume that he was wrong or right. I read it with an open mind. I double checked what was said. And so I could be confident that in the end, oh no, these apply, especially when I found the part saying that these rules apply in all cases, except the ones that expressly are excluded. So, and Stares at Plant says that I believe learning the court rules is 10 times more important than learning the laws. They both change frequently. I'll be honest, they both change frequently. But the best thing you could do is to learn, if you want to learn something more innately and have it memorized, the court rules would be very helpful to you. And the federal court rules, are oftentimes very similar to most states' rules. Now, Louisiana, if you're watching me and you're in Louisiana, dude, I'm sorry, but that state's all messed up. I went down there after Hurricane Katrina to help with the legal relief efforts, and it is a nightmare down there. It's like a whole nother planet. I don't know what they were doing. But at any rate, the U.S. Constitution applies, but beyond that, nothing else is the same at all.
Well, and don't you think, I mean, at the very least, having the table of contents of the court rules of your state and the federal in your head somewhere, so that when you are faced with something, you're going to be like, wait a minute, there's something I can do to fight back, whether it's this motion or whatever court rule says you can do that. So even the basics, you don't have to study it wholly, but definitely get the outline of what the court rules are at the very least.
Yes, at least be like me and just at least know where to look. Have them printed out and ready to go. Be ready to print them off every year or two at the most, because they change frequently. Have them at least on your computer so you could do Control F or scroll to the table of contents. At the very least, have a printed copy of the contents, the table of contents of your state statutes and your court rules, so that you can look through those, the most expanded version that they have. Look through those so that you can then go, okay, I'm going to look up this section online. It's super important, because the more you get the basics and you know where to look, the more you can call them out for their garbage and say, Ipse Dixit doesn't work here. You can't say it is and have it be so just because you say it is. So anyway, that's really the main point I wanted to throw at you guys today, because I was so disgusted at their it's just frustrating.
Makes me think you're all playing, and the attorney is somebody that sees you do something, they don't like it, so they run to the teacher and say, hey, so-and-so did this, and they're throwing a fit. And so all they're doing is pointing at what was done wrong and not the whole picture, I guess. And nothing maybe was done wrong, obviously, in this case. Just childish, the way, I guess, is where I was going.
Yeah.
I mean, let's be adults here and have a real conversation. Respect me enough I took the time to tell you what I thought. Now you give me that time to tell me what you think, and let's see if we can come to an understanding between each other. Yeah. Because what if they've been speaking another language and it wasn't until an interpreter came that you understood that they were saying, you're like, wait a minute, you're right. That's not the case in this situation, but it could be. They could have an issue with you that just because, yeah, anyways, sorry.
Yes. So, above all else, guys, I don't want you to give up on, I don't want you to be intimidated. Don't give up. Don't be intimidated. Don't be arrogant either. That's a very fine line. Don't be arrogant, but don't be intimidated. Be educated and be confident and be willing to re-educate yourself or refresh yourself on what the court rules or the laws or the Constitution say about any given topic, and be willing to, stand out in faith on your own and say, this isn't right. Let's see here. Ipse Dixit, the Liberty Cause on YouTube says, Ipse Dixit is the main form of law practiced in Deltona. The city attorney has nothing but because we said so to turn to. She certainly has no understanding of law. I thought you guys were replacing the city attorney. I heard Anthony Sabatini was even looking at trying to get that gig. I may have had someone in Deltona city government ask me to apply for the city attorney position a few months ago, but told them, if they want to pay for the Florida bar exam, maybe I'll consider it, but I'm not doing that at this point. So anyway, so I think that we've been able to answer the questions and concerns that you guys have had. I'm not sure. So yeah, I'm not sure. Excuse me. Hopefully I didn't skip over any questions, comments, concerns that you guys had. There was a lot of conversation today. But I just realized we didn't have letters of what is his I can't remember what his YouTube name is now. You are muted for some reason. Here. Unmute.
This is a public service?
Yes, this is a public service. That's his YouTube handle. I just realized we didn't have him on here today, but I know that he's in the background fighting the freedom fight. Talked to him yesterday. He's helping me on following up on some stuff. So anyway, don't just take no, but learn how to take no and run with it in the right ways. That's the biggest thing I want you guys to know, because so many people either completely shut down, they're anti-conflict, they just hate the conflict of any kind. So, they don't want to be if the government told me to do this or that, or, an attorney told me, okay, fine, it must be true, and I just won't fight it. Don't do that. But don't be, so, I don't know, I guess just arrogant. Don't be arrogant so that you're out there fighting in the wrong ways and saying, oh, well, this court just doesn't have jurisdiction over me, so I'm just not going to respond to this lawsuit, or I'm not going to do this or that. No, you still would have to respond, even to say, I'm responding to let the court know that there is no personal jurisdiction here because of XYZ. Or I'm responding to let the court know there's no subject matter jurisdiction, or whatever the case is. You can't ever just sit on your rights and expect people to follow or abide by, your rights, if you're just going to sit there and just expect things. I mean, really, then that makes you an entitled Karen, and we already have way too many of them. So be willing to stand up and respectfully follow common sense. Fight back in the right ways. And really, it starts with educating yourself and making sure that you're prepared. So, sorry,
So there's that somebody pointed me back to Rumble.
Before you do that, real quick, Joe on Facebook says, the abortion issue is a conflict of rights. No one likes hearing that or talking about that, though. And Joe, you're right. We did several full episodes talking about that very thing. In fact, when it was on the Michigan ballot, Proposal 3, I believe, was on the ballot. Whatever proposal it was bad. They all passed. They all sucked. Anyway, we talked a lot about that at the end of last year, or in November and December, October, November, December of last year. We did a lot of episodes about that, specifically talking about what those conflicting rights are. Rights of children, rights of fathers, rights of mothers, even rights of society, and how society is involved, and what is entailed there. So please check that out if you haven't already. We certainly have the slideshows and the PDF documents that went along with that as part of those Constitution segment recaps too, so you can just kind of take a look at that to start with. But you said there was something on YouTube. I mean, sorry,
yeah,
Rumble.
they were redirected me to Rumble. I was trying to. We know we are not mass rule. Do we just need a large quantity? Oh, sorry, I'm missing. What is the general process of peacefully protest and abolish our government, especially the non-elected ones? And then they talk about we know we're not mass rule, and that we just need a lot of people involved. We establish a government. Is it a trust indenture? If they have bad or confusing rules, that should be removed as well. So I think they must be somewhat new to finding us. I think they might be better off going to our website or watching some of our other videos, but I don't know if you had a general.
Yeah, as far as getting rid of bad people in government or whatever, we've had a lot of episodes talking about all different kinds of things, recalls, oh my goodness, quo warranto, and other kinds of lawsuits. Man, you're throwing me off my game. That's not what I was prepared to talk about, so I don't have all the terms on the top of my head. But we've talked about various different kinds of options on how to challenge or remove people from office. What if they have not taken that oath that they're required to by law? We've talked about what the procedure for that is. What steps can you take, especially in Michigan law? I've gone over that specifically about what are the steps, what can you do, what is the government or certain government officials required to do when the oath of office isn't taken, or when whatever. And recall is one of the biggest options in Michigan. It's not necessarily a good option in a lot of other areas, or at least the process is the procedure is a little different in many places like Florida, for example. Otherwise, planning for the next election, if it's something that is an elected position. If you're talking about a non-elected position, going to the people who are elected, who are in charge of putting that person in that place. So if you're talking about, for example, at your city level, go to your city council or city commission, whatever they call themselves, and talk to them about, removing certain positions that shouldn't be there, or whatever, certain people that are, committing malfeasance while in that role. There's all kinds of different ways to address that, but it is a big thing. It does take a lot of people being involved and passionate about it. I mean, one person can make a difference. One person can absolutely make a difference, but it obviously works better and faster if more people are on board with you. So making an organized effort is really the best thing, and trying to figure out how to attack. What do you want to attack? Do you want to attack? You also mentioned there's too many confusing rules and procedures involved. Do you want to attack that side of it first? Do you want to attack the positions themselves being eliminated? Figuring out what your priorities are, which problems you want to address first, and then go from there. And it's all doable. It's all something that you could have on your lifetime checklist of restoring freedom, because there is no Staples easy button for any of it. But we can get it done if we work hard enough and smart enough about it. So all right, guys, thank you so much for joining us today. Wow, a whole hour on Ipse Dixit alone. That is impressive, to say the least. And I'm sorry I looked like a Smurf again today with the blue lighting, but it's way too hot in my office, even though it's only like 70 degrees outside. So it's just weird. I don't know, but I had to have air blown in here, which meant I had to not have my little reflective green screen whatever stuff going on here. But anyway, thanks for joining us today. Make sure to check out our I can't even think today. Our Tuesday way to get no. Our Tuesday true or false Tuesday true or false question of the day. Lori, can't be that mean to me and throw me off.
I was trying not to laugh.
But we have a Tuesday true or false question about Ipse Dixit. So check that out on YouTube or Facebook. Excuse me. Nope. No, I'm wrong again. YouTube or Telegram. t.me/restorefreedom or youtube.com/restorefreedom will get you to those areas, and you can take those polls. We also will post the answer to those on social media at 10 p.m. tonight. So you have from now until 10 p.m. to answer if you have not already. Otherwise, wait till next Tuesday to answer them. But do make sure that on to tomorrow, on Wednesday, you check out our Wednesday Way to Get Involved challenge. Thursday, of course, will be our probably 10-minute or less Constitution segment recap video, mostly because TikTok lies. They told me I could upload a 30-minute video, but then when I uploaded a 15-minute video, they said that it was going to be broken down into 10-minute segments anyway. So, liars. Anyway, I will speed talk or cut out big sections if I need to, but that Constitution segment recap and either a PDF or a slideshow will be accompanying that, so you can check out all the stuff we've been talking about today and in more detail on your own. And then Friday's freedom fighting tools. Don't forget, every Friday we share with you at least 3 freedom fighting tools. Most often they are free, but they are essential to the various aspects of your freedom fight. On Saturday, it's your way to get involved to either purchase a Restore Freedom wonderful pop socket or window decal, or donate to one of our specific endeavors that we have. Sunday, we often have a biblical insight passage posted, and we'll send out our weekly newsletters. It does take sometimes even more than 8 hours for the whole thing to spool and get out and whatnot. So sometimes they don't get delivered till Monday for some reason. But at any rate, I greatly appreciate you guys joining us today. I look forward to having you join us on all of our future segments this week, and of course to have you join us next week. Again, I'm constitutional attorney Catherine Henry, and this is Liberty Lori, and it's been fantastic to spend season 2's episode 15 on Ipse Dixit with you today. Thanks, guys. Have a great day.